Well, there are two basic kinds of clawbacks, as we discussed, preferential and fraudulent conveyance. So I'm going to talk about some preferential transfer cases first, and then talk about some fraudulent conveyance cases. The first case I want to talk about is kind of an odd opinion. Um, this 2005 case of Delaware. And both the debtor and the defendant are in the apparel business, and payments are made in the preference period to the defendant in a fairly substantial amount. The defendant files an answer. It sets out some affirmative defenses, and plaintiff files a motion for summary judgment. Defendant does not respond to the motion for summary judgment and does not submit any evidence. This opinion sort of gives me a excuse me, sort of gives me a queasy feeling, because I just have a feeling that someone messed up here in a pretty serious way. They either didn't meet a deadline, or for whatever reason just did not file a response to this motion for summary judgment. And I know it's almost always better to file a response. So who knows? Who knows what happened here? At any rate, the court ruled for the plaintiff because there wasn't any opposition to the motion. But the takeaway in this case is that an answer was filed, arguing that objecting to the plaintiff's assertion of insolvency, that the debtor was insolvent during the time of the transfers. And the court stated, and it's important to know, that there's a presumption of insolvency in the 90-day period. And for the defendant to win on that issue, the defendant has to bring out or present some evidence rebutting that presumption. So, and if the defendant doesn't, then that presumption carries the day, which it did here, because the defendant didn't do anything, just filed an answer. The defendant also asserted some other defenses, but didn't provide any evidence. This is the statute 547B. This is the laundry list that the plaintiff has to prove again. And, the takeaway here is that it's not, in most cases, I mean, all this can be argued about, but the fact is, in most cases, it's not that hard to prove this laundry list. That the transfer was to the benefit of a creditor, that it was made on account of an antecedent debt, that it was insolvent, there's a presumption, and that the creditor got more than if a case had been filed under Chapter 7. And because, why? Because the creditor typically gets 100 cents on the dollar. If there had been Chapter 7 bankruptcy and the debtor is insolvent, obviously the creditor would have been paid less. So it's a lot of this is not, in many circumstances, not a big, not an uphill climb for the trustee. And the point of that is, you've got to present a case. You've got to present a defense based on 547C, which lists the defenses. So I guess that's a takeaway from this case. The takeaway from this case is you better make sure your lawyer files a response when you get a motion for summary judgment. I don't know what happened in this case. I don't think I've rarely read an opinion like this, where there's an answer filed and it's a substantial amount of money and there's just no response to a motion for summary judgment. I find it hard to believe they had no defenses. At any rate, the plaintiff submitted evidence as to the antecedent debt issue. Not rocket science. We owed the money. It's the antecedent debt. And noted that the defendant did not rebut the insolvency, and this defendant is basically done. Well, I'm surprised that there was an opinion. I mean, usually if there's an opinion in the law books, there's a an issue, an important issue that the judge wants to rule on, and it's an important precedential issue. In other words, it's an important issue for later decisions. But here, I guess the precedence is don't default on a motion for summary judgment. Second case I'm going to talk about is an older case from Ohio. And I'm not going to say it's a tragedy, but it's a case where it's a situation that if the defendant had taken just a little care in following the proper procedure, doing some paperwork, could have saved quite a bit of money. And I'll explain why. So the defendant is a provider of fur, and the debtor is in the business of retail selling of furs. And the defendant provided some furs on a consignment basis, a verbal agreement, I'm sure, with the store owner. And if you sell it, I'll get paid. If you don't, give it back to me. I'll give the furs back to me. So they didn't sell for whatever reason. Obviously, the store wasn't doing well. Filed bankruptcy shortly thereafter. So the minks were given back to the defendant. Unfortunately, they were given back to the defendant during the preference period. Never a good thing. The problem here is that the defendant, Almiro, didn't file a financing statement and didn't provide other indications that I was supposed to under Ohio state law to be able to assert that title did not pass to the debtor and that there wasn't another kind of relationship. Anyway, trustee sued, of course, and sought summary judgment. Trustee went through the laundry list that he had to approve. It wasn't a big deal. Did that. And of course, in response, Almiro contended, "Hey, I'm not a creditor. There wasn't any transfer of property. It's my property. It's my furs. What are you talking about? They didn't owe me money. They just had to get my furs back." So, sort of a common sense argument. Hey guys, let's just come on. Let's be fair here. We'll see how well that works. Okay, that's the issue. That's the statute. Here, I think one of the main issues is: was it a transfer of an interest of the debtor in property? Was it? Did this have anything to do with the debtor? These furs. I'm not going to go into the definition of transfer, but that's also relevant. But I think the most important question is, was this property or was it not property? And the problem here is that Ohio had a specific statute on what's consignment or what's classified as sale or return. If it's classified as sale or return, that means if the debtor had creditors could reach this property and could be considered property of the debtor. So you don't want to be sale or return. You don't want to be in that category if you're selling on consignment in Ohio. And so there is a way to get out of that category. And there it is. You got to do some things. You got to file a financing statement. Or you have to put up some kind of a sign, evidenced by a sign that this is a consignor, or establish that this business is known to others to have consignment. Some kind of notice to people. Hey, these guys are always selling consigned goods. So we don't expect, if we lend them money, we don't expect that we're going to be able to levy on some fur coats because these guys are known to be consignors. The statute tries to be fair to creditors as well as folks doing consignment deals. And to be fair to creditors, I have to say, it makes sense. You give some kind of notice so that the creditor knows that this debtor doesn't really may not have any assets. This is all consignment. Excuse me, it's all consignment stuff. So they should be on notice of that before they're lending money or doing business, extending credit. Unfortunately, Almiro didn't follow the procedure. Um, just did things on a handshake, which I'm sure is a tradition. But tradition notwithstanding, the court ruled against the defendant. Court went into a very elaborate opinion, the definition of a creditor, someone that has a claim, and here there's no doubt there was a claim because the defendant didn't get coats back, would have had a claim against the debtor. They weren't my coats, would have had a claim. And the court went through the whole laundry list of the plaintiff's burden of proof and found without a lot of trouble that that the trustee met its burden, including the property issue. The real conclusion here is, if you're going to be in business, you got to do the paperwork, because if a client goes bankrupt, especially if you sell on consignment, it's not going to be good. Not good. Not good at all. It depends on the state, what the state law is. Let me say this. It's not going to be good in Ohio. I can definitely say that. Whether it's good in another state, you've got to find out. Because if there is a bankruptcy, you're going to have a problem. Okay, I'm going to talk about the ordinary course of business defense, which is the favorite flavor among defendants as far as the defense to a preference case goes.
Okay, the first case I want to talk about is Terry Manufacturing. This is a 2005 district court level case, so there was an appeal to the district court from the bankruptcy court level. It's Alabama. What you have to know about this case is that it was decided under a law that has since been amended. In 2005, the law was amended, but it's important to know how it was amended, why it was amended, and it'll help you understand the current law. So I'll go into that during the case. This is a pretty common pattern in the garment business, I've found, garment industry. Very loosey-goosey with payment terms and payment. And here, payment was supposedly 30 days, but most of the time payment came from 98 to 321 days. This is a garment industry business, a sewing contractor, and a shirt manufacturer. So the sewing contractor got paid very irregularly. Then there was an attempt to get current, sort of a settlement of past payments and a flat payment per week, and then that went on for a while, and then the debtor went back to its old ways. So this is sort of a common fact pattern where there's just very late payment in the comparison period. In ordinary course, what we do is we take two periods: the preference period, the 90-day period, and then we compare that to a past period. It could be a year, it could be 2 years, it could be longer. But basically, ordinary course doesn't mean ordinary course. It means consistency. It's the consistency defense. If you acted the same way, if the parties acted the same way in the preference period that they did in the comparison period, then they acted consistently, and that's strong evidence that the parties were acting in the ordinary course of their business affairs. And ordinary, you have to define ordinary as consistent. So here, they're paid very late. They're paid all over the place. And if they paid that way in the preference period, there's arguably an ordinary course between the parties kind of defense. So during the 90-day preference period, paid very late, between 138 and 182. And so, is there a consistency defense or not? We'll find out. In 2005, where at the time this case was decided, the case law was not the case law, the statute was a little bit different. It was different in the sense that you had to prove two things: prove ordinary course between the parties, and you had to prove that the transfers were made in the ordinary course of the industry. Um, Typically, to prove that the payments were made in the ordinary course of the industry, one way of doing that is an RMA report. Risk Management Associations in the business of compiling all this data, and so we use them a lot. You order a report, find out what the days outstanding are for the industry, um, for the garment industry, or for this particular part of the garment industry, and so that was done in this case, and to try to prove the industry standard. What's different now is that you have a choice. You can prove the industry standard. You can prove the ordinary course between the parties. You can choose. Before 2005, you didn't have a choice. You have to prove both. It was actually much harder to defend the preference case. So, at any rate, the bankruptcy court ruled in favor of the trustee, and let's find out why. The arguments: trustee argued that the inconsistency with the industry norm, that was his main argument. The debtor argued that it was consistent, that the conduct was consistent between the parties, and given the long relationship of the parties, it should be allowed to qualify even though it departed from the industry norm. That's the issue. This is the statute, 540. This is the relevant part of the statute. This is yellowed out, 547C, because this is the industry standard, and that was the main issue in this case. But obviously 547 C2, A, and B are also important, especially B. That was the argument of the defendant. 547 C2B, made in the ordinary course of the business or financial affairs of the debtor and transferee. 547 C2A, by the way, is not litigated very often. It means that debt was incurred in the ordinary course of business. So for an example of a debt that's not ordinary, let's say you hire someone for bankruptcy counseling, the plaintiff, and then pay them. The trustee might say, hey, that's not really a debt incurred ordinarily by this debtor in the garment business. So that's what that means. Was it an ordinary sort of transaction? It's not very often litigated. Well, the court found, okay, it's ordinary between the parties. Congratulations. But it's not ordinary for the industry. So you lose. And that's basically what happened here. They lost based on that. These days, in our more enlightened age, this could never happen because you have a choice. And so this would not happen. This case would have been won by the defendant, I'm happy to say. Unlike the dark old ages. This is a part of the opinion. I'm not really going to go into it. It says basically what we just discussed. This is also sort of a repetition. What's interesting to know about this case is that it deviated a little bit from the range in the what do you call it, the base period or comparison period. But the court took into consideration that this was a very long relationship, and so the court's going to give some leeway if the six payments don't correspond exactly, because the court doesn't want to make an arbitrary decision based on a short period of time. And long story short, it was consistent enough to be ordinary course between the parties. I'm talking about this because this is still the law. This part of this decision is still relevant and still the law. Ordinary course between the parties is still analyzed in the same way. Of course, at the end of the ruling, the court refers to the dramatic departure from the norm of the industry standard. But again, we don't have to worry about that anymore. This slide refers to an application of the law that doesn't really exist anymore. And what that was is the case law said if the relationship was stable, then the defendant would not have to prove the industry standard defense. And that was because it was very hard to prove the industry standard defense every time. And so the courts were cutting defendants slack on that. But now you don't need to prove the ordinary course. You don't need to prove both ordinary course between the parties and ordinary for the industry. You can choose which one. Most people choose the first one. One thing to notice here is that the court noted that there wasn't any particular, they were all over the place. They paid all over the place. They paid late, they paid on time, they paid pursuant to a plan, then they stopped paying pursuant to a plan. They were all over the place, but they were consistent in being all over the place. So you can be all over the place as long as you continue being all over the place in the preference period, because that's a pattern. That's the lack of a pattern can be argued to be a pattern as long as there's you want to always argue consistency, and the lack and all over the place is a form of consistency. But here the court is saying, well, it also shows it wasn't a stable relationship, and the court didn't allow a proof of the industry standard. It wasn't stable enough. But you don't need to worry about that because that law has been amended anyway. So this is the summary. This is not really relevant currently because we don't need to show the industry standard, but it does give you a concept of what courts consider as far as comparing the preference period with an earlier period. How long has the relationship? The longer, the better, if it's consistent. So particularly long-term relationship will be more likely to get the judge's agreement that the payments were made in the ordinary course. Okay, here's another case in the garment business, 2003, bankruptcy court level. So this case answers that question you've been waiting to ask. What if there's only one transfer during the preference period? It's a new relationship. There's no history. How are you going to prove ordinary course? There's nothing to compare it to. Okay, I won't leave you in suspense for too long. All right, so debtor was in the business of selling casual attire, and Golden was in the business of selling sweaters. So if your mom told you don't be a big shot, wear a sweater when you go outside, you may have bought them from Golden. Who knows? Anyway, the sweaters were shipped to Foreman, and then an invoice was later sent, and the invoice said net 30 on it. Okay, the payment was made 19 days late, 19 days after the due date. So it wasn't paid in 30 days after the receipt of the invoice. It was paid in 49 days, whatever, 19 days after. So the trustee said, hey, the only thing we have to look at here is whether this thing was on time. And it wasn't even on time. It was late. It was over 2 weeks late. So not in the ordinary course. There's nothing else to go on, and you're out of luck. Defendant didn't give up and basically said, hey, 19 days is not the end of the world. And we have a very informal business. We don't consider that a big deal. The defendant also looked at the schedule, did a good job. Their lawyer looked at the schedules that were filed by the debtor, and the schedules showed that this debtor was solvent. So another argument was that this company was solvent, so it can't be a preference. So was the debtor insolvent or was it solvent? Is it ordinary course or not? That's the statute, 547B. That's the statute. Part of the statute saying that the trustee has to prove insolvency. 547B, ordinary course. Okay, well, the court used the balance sheet test here. Very simple. And the court noted that, the schedules were no good. The schedules were all wrong. They didn't list $6 million in creditors, and they overstated the value of their inventory by 6 million, and other inaccuracies. So the takeaway here is, if you look at the schedules, the court's going to they're going to look into whether the accuracy of the schedule. The schedule is not going to be by and in of itself enough evidence to show insolvency, and here's why. So the court concluded it was clearly insolvent. The company was insolvent. Okay, court noted there's a split in the circuits at that time. I'm not sure there still is, but at that time there was a split as to whether, if you're a one-off, have one transaction, you can be granted or take advantage of the safe harbor of ordinary course. Well, the court didn't want to hear anything about that. Not being that just because there's one transfer, you can't have ordinary course. It definitely could have ordinary course. The question is whether this defendant has ordinary course. Well, I love this quote. These guys were proceeding by the seat of their pants. You know, I wonder if that was said because they were in the garment business. I just wonder whether this court is one of the is maybe the only court with a sense of humor. Anyway, the point is, these guys have very informal agreement. We're going to pay. We'll ship the sweaters. Don't worry. We'll pay when we're going to pay. We'll pay. Don't worry about it. And they did pay. 19 days late, but who cares? That's basically, I think, what the court ruled, is that it's ordinary. The court ruled there's no evidence of any unusual conduct. You kind of put the burden on the trustee here. And I'm going to continue the next slide. Okay, so there wasn't a course of dealing, but let's go on. Yeah. There was also evidence, and I think this is important, that payments from Golden received from its other customers were always late. I mean, who pays in 30 days? Everybody knows that. Other customers, and they did an average. They provided evidence. 18 days, not late. It's not late, so it's not considered late, or at least it's pretty ordinary. And so there was testimony as to that, and the court held, this is good enough, and granted the defense, which I think makes sense. Yeah, takeaway here is there is a presumption of insolvency in favor of the trustee. So unless you bring forth evidence contesting that enough to overturn that presumption, you're not going to win on proving insolvency. And here there wasn't enough evidence. Here the creditor did, I think, an excellent job, provided testimony of how it dealt with other people, and did provide evidence that this was in the ordinary course, even though it was one transaction. Okay, this is another case. This is another case. Youthland against Sunshine Girls. So Youthland was in the business, a specialty store selling children's clothing. Sunshine Girls was the manufacturer, and Youthland ran into trouble. Apparently, unfortunately, went bankrupt. The manufacturer gets sued, and of course, there's the ordinary course defense. And the question here is there an ordinary course defense? Parties stipulated to some of the facts, but the issue was a lot of the payments were made very late, and the trustee pointed out the average lateness during the preference period was higher than the average lateness during the year prior. So the trustee was saying, hey, it's not consistent. They were later, and there's no ordinary course defense. Trustees are always the bad guys, in my opinion. 547C2A, that's part of the relevant statute. That's whether the debt was incurred. I'll go into that in a second. That's the other part of the statute, and that's the industry standard part of the statute. That's the rationale. We're supposed to protect people, not to disrupt trade, unless there are unusual actions or sweetheart deals that need to be reversed or punished. Okay, so the first thing is, was the debt incurred in the ordinary course? What that means, almost never litigated, very rarely, is that, is this ordinary business? In other words, uh, you know, Youthland did not all of a sudden decide to go into the popcorn business and bought popcorn. That would be maybe not incurred in the ordinary course of its business. This was to buy manufactured wholesale clothing that was going to resell. So of course, it's in the ordinary the debt was incurred in the ordinary course of the business. Second element, was it the ordinary course between the parties? And here is the question. It was consistently late, and in some instances, those payments exceeded 100 days, which is very late. Also, an important factor here was, what were the collection attempts here? Normally, when you're very late like that, over 60 days, a debtor, a company, any company is going to start getting calls. Where's the payment? We're not going to do business. We're going to, various and escalating forms of harassment. Now, anything over 90 days, the harassment triples. But here, the court noted, hey, just normal account statements, maybe a phone call once in a while, nothing special. Yeah, so the court focused on that a lot and said, look, both parties acted like this was in the ordinary course, and therefore it was in the ordinary course. It wasn't a big deal to them, so we're not going to make a big deal out of it. And then Sunshine's expert witness testified that anything under 120 days, when you're dealing with a specialty shop in the children's apparel business, is going to be on time. Why? Because they're small, limited capitalization, they pay slow, they have cash flow issues, whatever. We're used to that. Not a big deal. And the court agreed. The court now, and this is not going to happen. In other words, the court has to deal with the industry standard, and so does the defendant. Now, industry standard probably wouldn't have been even raised. I probably wouldn't have even used it as a defense because I don't have to. But before 2005, part of the defense. And the court, in my opinion, is just bending over backwards. The statistics, I'm sure, were not, in the apparel industry that 100-day terms were normal. So it was bending over backwards, saying you got to really look at the size, not just the industry. Goes on and on. Bippity bop. Court finds for the defendant. This is ordinary because parties treated it as ordinary. So it's an important takeaway, what the party's conduct is like, and to be able to use that as evidence, even though when you look at it, maybe they paid a little bit later in the preference period. It doesn't matter. The court's opinion was, nah, it's not important. I mean, there wasn't an escalation of collection pressure. That's the key. That's the key factor that the court considered in deciding whether this was pretty much ordinary between the parties. Yeah, what's also a good important takeaway is that this is very fact specific. Court's going to look at a lot of different things. I think the court wants, basically to make a judgment call or get a feeling for how these guys did business and whether anything really significant changed in the preference period. And here, that's what the court did. These guys, they extended terms, they accepted late payments, they accepted this was part of the, as they say in The Godfather, this is the business that we chose, and they accepted lateness. So the case, it's an old case, 1984. It's still good law though. It's just an example of another garment industry type case. This involved a shoe wholesaler had an agreement with a retailer. Part of the agreement was to collect sales receipts, and unfortunately here, the IRS levied on these sales receipts, and that was sort of the weird fact pattern here. And the question is, Garland went bankrupt, and then the IRS had done that within 90 days, so the trustee sued the IRS for a preference. So the argument was that these were either in the ordinary course or protected by 547c6. I'm going to flip through this very quickly because I don't think there's that much to learn here. That's obviously the statute I'm going through. And this was amended in 2005, this statute, so it doesn't look the same now. Well, let's go to the opinion. First, the court finds that yes, notice of levy was made and collection was made during the preference period, and the IRS would have received more, did receive more than it would have received had there been a Chapter 7 bankruptcy. So, the court pointed out that Section 545 can provide a safe harbor for certain statutory liens. However, taxes aren't one of them, so they're out of luck on that. But the court says that the payments were to the IRS on a notice of lien were in the ordinary course. I think this is a very surprising conclusion. It doesn't seem to me like that would be the ordinary course of anybody's business. But that was the judge's decision. That this happens, I guess, in businesses, that the relationship between Garland and Sheldon, the shoe manufacturer, was in the ordinary course, and that this happens that this all happened in the ordinary course. Receipt of the payments upon demand made was in the ordinary course of business of the IRS, because that's its collection process. I don't know. This seems to me to be very, very liberal in favor of the IRS. I'm a little biased. The IRS, of course, is my favorite uncle. Anyway, that's all I want to say about this case. It's an example of the IRS not being liable for a preference lawsuit. I guess maybe they're the only entity in the country that seems to get a free pass. Okay, I'm going to switch gears now and look at fraudulent conveyance. This is a whole different code section, and I'll talk about fraudulent conveyance as we're looking at the cases. I think that's the best way of doing it. Okay, this is a fairly recent case, 2006, Wisconsin. So keeping with our garment industry theme, debtor was in the business of manufacturing and selling T-shirts, sweatshirts, and other items with art on them. Anyway, so AU ran into trouble in 1996, and the owner, Walter, thought it was a good time to liquidate some assets and pay debt down to Wells Fargo. And so negotiations were started with Mr. Steve Sharp of Art Unlimited Sportswear, AUS, for the purchase of the assets of the company. So far, so good. Problem arose, well, not till later. Looking back, there was an issue when AU's owner insisted on a $600K payment to himself personally as a consulting agreement payment. And of course, AU went bankrupt, and as a trustee appointed, and the trustee sues the former owner of AU for $600K. And why would he do that? Well, the trustee is suing former owner for a fraudulent conveyance because company is essentially transferring 600K to the former owner. It's not getting anything back. It's just paying off equity and not getting anything for it. So 600K is going out the door. Creditors are are owed $1 million, and the assets that are left are not enough to pay them. And so clearly the company was insolvent at the time of the sales transaction. But this is one of the issues um, that was proven by expert testimony. Both the former owner and the bank asserted that they believed there would be enough assets to pay everybody uh, in full. So the former owner gets sued uh, in two ways, two counts, two different sections of the code. For an actual fraudulent conveyance, where there's an allegation of an intent to defraud, which actually in some states has can carry criminal liability. And he's being sued for a constructive fraudulent conveyance. Constructive fraudulent conveyance is more in the nature of the debtor got a bad deal, but there was no real fraudulent intent. The action hindered creditors, but there was not an intent to defraud them. So it's very different. This is the code section 548. It's applicable 548A1. A. This is actual fraudulent intent. A1A is actual, and then A1B is I'm sorry, 548B is considered the constructive fraudulent conveyance section. What's interesting also is that it's worth noting that under actual fraudulent conveyance, trustee doesn't have to prove insolvency because there was fraud. There's fraud here. We don't have to show insolvency. We're gonna nail the bad actors. But under B, it's constructive. And if the debtor hadn't been insolvent, there would be enough assets to pay everybody. It wouldn't be a big deal. No need for a fraudulent conveyance action. The only reason we're bringing a fraudulent conveyance action under B is to make sure the creditors are whole, or made whole, or at least made more whole. This is the defense. Transferee takes for value, so reasonably, that's been interpreted to be reasonably equivalent value, and in good faith. That's the defense to both sections, value and good faith. And you have to have both. Well, basically, the court disagreed with the trustee's allegations that there was an actual fraudulent conveyance and an intent to defraud, but did agree that there was a constructive fraudulent conveyance, and that there was an intent to hinder and delay, there was bad faith, and the debtor was insolvent, and the debtor received nothing for the 800K that was paid to the owner, or rather the 600K. Um, a lot of the analysis went to determining whether the debtor was insolvent, because remember, this is a constructive fraudulent conveyance. And if the debtor had been solvent, then so what? Well, the assets would have been sold, and everyone would have been paid. There would there wouldn't be any point to having a constructive fraudulent conveyance. But debtor was insolvent. The court heard testimony of the trustee's expert and determined that the value of the assets were much less than the liabilities. In fact, the assets were close to the transfer amount, 652,000. Actually, the negative value, the insolvency, was close to the transfer amount, $652,550. I wonder if that was a coincidence. Also, the court found that Wells Fargo was not liable as simply as an intermediary, and that judgment was entered against the owner and his shell company. This case involved a consignment, and so it's illustrative of what happens when there's a consignment in the context of a preference case. There's actually a preference case. This just sort of gives you a concept of an example of what can happen. So this is bankruptcy court level, 1992. So Alper is in the fur business, borrows from the bank. The bank has a lien against everything. Alper forms Just Furs, a separate company needed to do business as a discount furrier, grants a lien to the bank and everything, and transfers furs to Just Furs on consignment. So that's the scenario. Alper, of course, goes bankrupt. Trustee is appointed. Prior to the bankruptcy, the bank, Alper agreed to give up its furs that were being held by Just Furs on consignment to the bank. And so the trustee started a preference action and basically said, hey, the bank was paid within 90 days of the bankruptcy filing. How was it paid? It got the furs. This is our property. This is the property of the debtor, property of Alper. So Alper transferred property in the 90-day preference period, and the trustee sought to recover the property. Both moved for summary judgment, and I'll go into the issue in a second. Yeah, so these are the arguments. I mean, the basic issue is who had a superior right to the furs? Was it the bank that had a lien, or was it Alper? Since the furs were held on consignment. So the question is, does the bank prevail, or does Alper have a superior right? If the bank has a lien, it can't be a preference. Well, this is the applicable code section, and this is one of the exceptions to when a consignment agreement can be enforced or not enforced. And this section 3B establishes when a consignment agreement can be enforced against third parties. And that is when the person making the delivery establishes that the person conducting the business is generally known by his creditors to be substantially engaged in selling the goods to others, or entering into consignment type arrangements. This is another applicable section that actually contradicts the other section of this. And this is all state law. The court has to look at state law to determine property interests. So these are statutes relating to property interests in Illinois. This is the preference, 547B, the preference code. Well, the court decided there's just no doubt this was a consignment agreement between Alper and Just Furs, and heard testimony to that effect, and found that there was a conflict between the statutes, and resolved the conflict, and found that 2-3263 applies. Well, the court basically decided not enough facts, can't decide this on summary judgment, because there's a question of fact, and the question of fact is, did creditors believe that Just Furs was in the business in the practice of dealing in consignment transactions or not? It wasn't really proved, even though 79% of the claims against Just Furs was Alper. What about the rest of the creditors? And so there really wasn't conclusive testimony on that, and the bank didn't provide any testimony, and apparently neither did Alper. So that's the issue, and there has to be a trial on it, according to the court. There's another case involving the garment industry, involving the lien defense against the preference action. It just shows the importance of liens and perfecting your lien. It's a 2001 case, Texas. Debtor was in the business of manufacturing and selling women's apparel. CIT had granted loans, both pre-petition and post-petition. So post-petition had a lien on property of the estate for the post-petition transfers. And there was a dispute as to the CIT's lien on pre-petition cash. Trustee wanted to distribute it to unsecured creditors and use it to pay lawyers, what have you, administrative expenses. And CIT was, wait a second, we have a lien on this pre-petition, and so it's not available to anybody else. It's ours. Those are the arguments, defendant's arguments. I already explained that. And the trustee argument is that CIT didn't perfect its liens, and therefore CIT's security interest does not reach pre-petition inventory. Granted, it has a lien post-petition, but not pre-petition, and so that was the issue. And the argument is, if CIT has a valid perfected lien on pre-petition assets, then can't be subject to a clawback under the preference laws under 547B, and I'll go into why in a second. So that's the issue. That's the statute. The main issue here is 547B5. Would the creditor have gotten more in its alleged preferential transfer prior to the bankruptcy than it would have been paid during a bankruptcy case? And the point of that is that if the creditor or the bank had a lien, it would have been paid in full. If it was a secured creditor, it would have been paid in full anyway in the Chapter 7 case. So unsecured creditors are not being prejudiced. It would have been paid in full. No one's getting an unfair advantage by being paid. The bank is not getting an unfair advantage, and by being paid before the bankruptcy. Why? Because it would have been paid in full after the bankruptcy. It would have had a lien. Would have been a secured creditor. So that's the issue. Well, I think the bank was very well prepared here, and the court looked at all the evidence and looked at the assignment from Barclays, that the original loan was in 1987. In 1997, Barclays assigned an interest to CIT, and CIT filed a statement with the Texas Secretary of State, perfected its security interest, and filed an amendment to the financing statement, adding a new security interest in the debtor's inventory. So the court concluded that CIT had an uninterrupted, perfected security interest in the debtor's accounts and receivables and the proceeds therefrom. And that was not interrupted by the bankruptcy case. The bank was a secured creditor in the inventory and in the cash. As to the trustee's preference argument, the court said you didn't meet your burden of proof under 547B5. This creditor was secured. It's going to be paid in full anyway. Actually, the court found that they were unsecured as of the petition, undersecured as of the petition date. So certainly they did not receive more from the transfers than the bank would have received in a liquidation. They had security to spare. Well, the takeaway here is the importance of being a secured creditor, if you can be one. The importance of perfecting your security interests. There are a ton of cases where security interests are not perfected properly. and then the creditor is deemed to be not secured, or they're perfected late, or they're perfected during the 90-day period, and causes all kinds of problems. This is a case involving reclamation, another reclamation case, and this comes up a lot, especially in the clothing business, garment business. This is bankruptcy court level, 1983. It's an old case, but the issue still applies. Okay, so facts here. Sportswear manufacturer delivers sportswear to the debtor. Debtor goes bankrupt. Plaintiff, or rather, actually was the plaintiff in this case. Sportswear business realizes that the debtor was insolvent and sends a notice pursuant to Section 546C, which requires written notice within 10 days of, quote, receipt, close quote, of the product. And what the reclamation statute does, of course, it allows you to reclaim or take back the product. And the theory is it's not very fair. Someone's can't pay you and accepts product. You don't expect to get paid. They're insolvent, and this gives you a little bit of recourse. You can take your product back. Um, so anyway, that's the reclamation statute. And the question here is the sportswear company going to succeed in reclaiming pursuant to 546? Well, the debtor said when you handed or delivered the goods FOB to the shipper, that's when the debtor received the goods. Actually, there you go. That's the debtor's arguments. The plaintiff, the sportswear manufacturer said, no, that's not when I shipped. That's not when the debtor received the goods. It's not when I shipped the goods. It's when the debtor receives the goods, and the debtor didn't get physical receipt of the goods until November 24th. So the debtors already know we received them when you handed them over to the shipper, FOB, not when we actually physically received the goods. And according to the debtor's argument, of course, time ran out. The 10 days ran out. It's too late, and they can't reclaim the goods. By the way, this was decided under a previous version of the reclamation section of the Bankruptcy Code 546. It's since been changed, but the issue is still an important issue. When does the debtor, as far as the timing goes, when does the debtor receive the goods? So this is the old section, and again, it has been changed. And this is the UCC on which the code section is based. In other words, the purpose of the code section is to extend reclamation rights that you get under state law. If there were not a 546 section and you reclaimed your goods under state law, it would be preference because you're taking back product, you're paying yourself. It could easily be, and it is often interpreted as a preferential transfer. So 546 protects you from that. 546 permits it and protects it from later laws and protects the reclaimer from later lawsuit by the trustee. So this is the Kentucky version of the UCC providing for reclamation. There you go. Okay, so the question is, what does receipt mean? Did some legislative research apparently and decided the court did some legislative research history to interpret the statute, found that Congress's intent is that the seller's rights under 546C should be interpreted and construed in the context of the language of the rights given under the UCC for reclamation. 546 is meant to extend state law, so we look at state law and see what the applicable state law meant. Well, the judge looked at the state statute and found that no, it's not delivery, it's physical receipt of the goods that counts as far as the deadlines go. If the court interpreted it as the debtor wanted it interpreted, then State law essentially would be gibberish. So that doesn't make sense. So that was the court's conclusion. And the important takeaway here is that, well, this is an issue that may be litigated. And the important takeaway is the court's going to look at the state law and see how the state law defines receipt. In Kentucky, under this UCC interpretation, um, receipt is defined as actual physical receipt. And there's a section of the bankruptcy court's opinion. Now it's actually a longer period. It's not 10 days, but the issue could still come up again.